Good afternoon. This is Ellen Bonner. I am here to present the Medicare and Tricare Provider and Supplier Suspension webinar for Holland & Hart. I'm a former Holland & Hart attorney, and I've been asked to do a guest presentation on this subject. I'm with Callaway Bonner Law. A little bit about myself as we get started. I formerly was with Tricare as an agency counsel, and I have also been in-house counsel and an executive for Medicare administrative contractors as well as Tricare contractors. That was prior to my entering private practice. So I have quite a bit of knowledge about Medicare, Tricare, the policies, the suspension, the contracts, and everything that happens in the Medicare and Tricare world. First, we're going to talk about Medicare suspension. Medicare has the authority to withhold payment in whole or in part to providers and suppliers, not beneficiaries, for claims that are otherwise determined to be payable. All of this information can be found at 42 Code of Federal Regulations 405.370 through 377, as well as in the Medicare Program Integrity Manual at Chapter 8. There are two types of Medicare claim suspension. There's the fraud suspension, which is, and there is another type called a general suspension. Medicare suspensions of payment may be used when there's fraud or willful misrepresentations exist. That's called the fraud suspension. Or the general suspension may be used when there's an overpayment situation where the amount of overpayment has not been yet determined, or the payments to be made may not be corrected. Or if a provider fails to furnish records or other requested information needed to determine the amount due the provider or supplier. That is another type of general suspension that Medicare can put in place. And one of the questions is frequently asked, well, my Medicare claims have been suspended and payments have been suspended. Who made that recommendation? What happened? How did this happen? Well, generally, the CMS contractors, and the CMS contractors can be one of the MAC contractors, the program safeguard contractors, the ZPIC contractors, but they make a recommendation to CMS when there is a credible allegation of fraud that a provider has submitted false claims. So what is a credible allegation of fraud? It is not a very high standard. It's an allegation from any source, including but not limited to fraud hotline complaints, claims data mining, patterns identified through provider audits, civil false claims cases, and law enforcement allegations, investigations. And the allegations are considered credible when they have some indicia of reliability, according to the Code of Federal Regulations. So what happens is that the allegation of fraud will be reviewed by CMS's central office, Division of Benefit Integrity Management, Operations Fraud and Abuse Suspension and Sanction team. They approve the payment suspension action after the CMS contractor forwards them a draft of a proposed suspension and a brief summary of evidence. So there's not a whole lot that goes to CMS before a provider can be suspended. So it's an interesting process. The team reviews it, and then they approve it. And once the Medicare suspension is put into place, it's for 180 days, and it can be extended on a one-time basis for an additional 180 days. While all the suspensions of payments with credible evidence of fraud are considered temporary and will not continue after the resolution of an investigation, unless a suspension is warranted because of reliable evidence of an overpayment or that the payments to be made may not be correct. Medicare fraud suspensions are based on credible allegations of fraud, as we discussed, and they are almost an indefinite suspension pending the outcome of an investigation. CMS contractors have a considerable latitude in fraud cases when recommending Medicare payment suspension, and while an investigation for fraud is ongoing, generally the suspension is not listed. However, CMS may find that good cause exists not to suspend or continue to suspend payments if the OIG or other law enforcement agencies specifically request that a payment suspension not be imposed because such a payment suspension would compromise or jeopardize an investigation. In this case, this is where there's an ongoing investigation, and the agency doesn't want to tip anybody off that there may be a fraud investigation going on. So they, for good cause, may not suspend payments for some time, even though they know that the payments are fraudulent. There can be a determination that beneficiary access to items or services would be jeopardized by a payment suspension in whole or in part as to cause a danger to life or health. Sometimes this can be in like a rural hospital, or rural area of the country, and maybe there's only one oxygen supplier. And if they suspended payments to that supplier, then the beneficiaries may not have access to oxygen. So that is also a consideration that Medicare makes. Or if there's a determination of other available remedies implemented by CMS or a Medicare contractor more effectively or quickly to protect Medicare funds than implementing a payment suspension. That's another good cause not to suspend. So there's another method to resolve the issue more quickly by CMS. Or CMS can determine that a payment suspension or a continuation of payment suspension is not in the best interest of the Medicare program. They might find that they have other policy reasons not to suspend payments, even though there may be allegations of fraud. Reevaluation of suspension. So what happens is Medicare suspends for up to 180 days, and every 180 days after the initiation of a suspension of payments based on credible allegations of fraud, CMS evaluates whether there's good cause to continue such a suspension under this section, and they request a certification from the Office of Inspector General or other law enforcement agencies. The matter continues to be under investigation, warranting continuation of the suspension. This is a check by the agency to make sure that the suspensions don't languish and just continue forever without somebody saying, hey, this provider or entity was suspended. We need to come back and look and make sure that the investigation is still ongoing and that it hasn't been resolved. After 18 months of suspension, good cause to discontinue suspension is deemed to exist if there has not been a resolution of the investigation, except CMS may continue to extend if a case has been referred to or is being considered by the Office of Inspector General for administrative action, or if administrative action is pending, or if the Department of Justice submits a written request to CMS that suspension of payments be continued along with additional documentation. So that was generally the fraud suspensions under Medicare. The general suspensions can be because of unfiled cost reports. This is a case where a provider failed to timely file an acceptable cost report to Medicare. So payment to the provider is immediately suspended in whole or in part until cost report is filed and determined by the Medicare contractors to be acceptable. And what is particularly troublesome about this is that no notice is required to the provider for Medicare payment suspension due to unfiled cost reports. It just happens, and it can be quite surprising to a provider. This is also true of an unfiled hospice cap report. Medicare requires hospice cap determination reports to be timely filed in an acceptable manner, and if it does not happen, payment is immediately suspended in whole, or it can be suspended in part until a cost report is filed and determined by the Medicare contractors as acceptable. Once again, no notice is required. The payments just stop. Notification of suspension. There's a prior notification. Notification prior to suspension is required for fraud when it's either a suspension in whole or part, and the reason for making the suspension, unless it's based on failure to furnish the cost reports or hospice cap reports, if there's determined that it may be harm to the trust fund or perhaps fraud. These are all reasons that you may not receive a notification. So what is a provider to do when when all of a sudden the Medicare payments stop or they receive a notification? The reality is that the provider navigates the Medicare payment suspension process with very limited information about how and when the suspension will be lifted. They have an opportunity for a rebuttal, but and if you receive prior notification, you have that opportunity to rebut in writing to CMS about the payment suspension. However, and if you do receive prior notification, you have at least 15 days following the date, unless CMS imposes a shorter time, or perhaps they may extend the time for rebuttal period. If there's no notification, you also get the ability to rebut, but it's just after the fact of the suspension. What does CMS do when they receive the notification, the rebuttal to the suspension notice? Well, they first have to consider the rebuttal statement, any pertinent evidence submitted along with that rebuttal statement, and any additional material bearing upon the case, any additional material they may have in their files, etc. And then they must determine if the facts justify the suspension or if initiated justify the termination of the suspension. What Medicare then issues a notification of determination in writing with specific findings on the conditions upon which the suspension is initiated, continued, or removed, and provides an explanatory statement of the determination. What is important to know is that the Medicare determination of suspension is not an initial determination, and importantly, it is not an appealable decision. That truly hampers anybody who receives a Medicare notice of suspension. Now, turning to the Tricare suspensions, I'll give you a little history about Tricare. Tricare and Medicare share many of the same rules and regulations, but they don't share all of them. In fact, the Tricare suspensions are different and have different rules and notices that go out, and even have an opportunity to present in person to Tricare if you've been suspended. Generally, Medicare and Tricare march along following the same, very similar rules and regulations, but in this case, they do not. In fact, the authority to suspend lies in the hands of the director of the Defense Health Agency. And by the way, I'll go back a little bit. About a year and a half ago, the Defense Health Agency came into being. It combined many, many different agencies within the Department of Defense regarding health care. And the former Tricare management activity was folded into the Defense Health Agency. The Defense Health Agency has two offices, one in Washington, D.C., and one in Aurora, Colorado. And the director of the Defense Health Agency is a general appointed and confirmed by the Senate. And that is the person who makes the ultimate decision on any suspension and issues all letters of suspension. However, he is assisted by the Office of Program Integrity within the Defense Health Agency and is, as well as the General Counsel's Office at the Defense Health Agency. So why does the Defense Health Agency exclude people or suspend people? Well, if there's a criminal conviction or a civil judgment involving fraud by the provider, fraud or abuse under Tricare by the provider, exclusion or suspension of the provider by another agency, a federal government, a state, or a local licensing authority. One of the things to keep in mind that it's not, when we say a provider, an entity can also be excluded or suspended under Tricare whenever an entity is found to have a person convicted of a crime involving Tricare fraud, if the person has a direct or indirect ownership or control interest of 5% or more of an entity, or as an officer, director, agent, or managing employee of an entity. So entities can be excluded or suspended. Pharmacies can be excluded or suspended. And it doesn't take but one person within that entity who has is in an executive level position or even just a managing employee for an entity to be excluded. But an entity won't be excluded or suspended from Tricare for employing the provider who has been sanctioned by Tricare. However, the entity will be denied Tricare payment for any services furnished by a sanctioned employee. I'll go back onto our slides now. Tricare suspensions involve participation in a conflict of interest situation by the provider. Those are generally cases where the provider is maybe a military personnel and moonlights at a hospital. You can't, that military personnel cannot, or the entity cannot be paid for any services provided to another Tricare beneficiary as long as they are moonlighting and are active duty in the military. So that's an interest, would be considered a conflict of interest situation. And suspensions can be made when it's the best interest of the program or Tricare beneficiaries to suspend a provider. Generally, Tricare suspensions are effective 15 calendar days from the date of the written initial determination. In other words, the head of the Defense Health Agency sends a letter saying we are to the provider entity saying we are suspending you, and effective on a certain date in the future. Tricare also has what's called a temporary claims process suspension. It's invoked to protect the interests of the government for a period reasonably necessary to complete investigation of appropriate criminal, civil, and administrative proceedings. It delays the ultimate payment of otherwise appropriate claims. In other words, they just suspend the payment of the claim. What happens is the entity may still provide services to Tricare beneficiaries, or the provider provides services, and the claims are valid claims, but they are not paid until the suspension is cleared up. So if somebody is found is suspended and later the suspension is lifted, then those claims automatically become payable. Tricare participation agreements. Tricare participating provider cannot repudiate the participation agreement. It remains in full force and effect. In other words, if you're participating in Tricare, then you're still required to see the patients even though you're suspended. Tricare claims subject to temporary suspension are eligible to be paid, as I stated, once the temporary suspension ends, unless they're deemed inappropriate as a result of criminal, civil, or administrative remedies ultimately invoked in a case. Tricare notification. The Tricare notification is given to an affected provider, the Uniformed Services Military Treatment Facilities. That would be the Army hospitals, the Navy hospitals, the Air Force hospitals. They're given to health benefits advisors, Tricare health benefits advisors, as well as Tricare beneficiaries and sponsors. In addition, notice may be given to any information or news media and any other individual professional provider or institutional provider as deemed appropriate. Now, what you should know, though, in addition, is that a temporary claims processing suspension by Tricare is not considered a final or formal agency action. Therefore, on a temporary claims processing suspension, the basis of the suspension generally won't be disclosed. And the basis of a temporary suspension can be a routine audit or an investigation of possible criminal violations. It can run the gamut for why an entity or provider is temporarily suspended. And as I mentioned before, the director of the Defense Health Agency may suspend Tricare claims processing with no notice to the provider or beneficiary. But in general, they give 15 days notice. Once a temporary suspension is ordered, the provider receives notification of temporary suspension and a statement of the basis of the decision to suspend payment. And unless the suspension is based upon an indictment or initiation of criminal charges, the notice describes the suspended actions or omission in terms sufficient to place the provider or beneficiary on notice without disclosing the government's evidence. There are cases where a Tricare beneficiary, can be suspended if they suspect their fraudulent activity on their part. So that's also a reason to suspend payment. What is unique about, with the Tricare suspension is that you have an opportunity to present to the Defense Health Agency reasons why you should not be suspended. Within 30 days from the day of notice, which may be extended to 60 days for good cause, the provider or beneficiary may submit written information, evidence, and argument in opposition to the suspension, provided the additional specific information raises a genuine dispute over a material fact to the director of the Defense Health Agency, or they have a written request to present in person evidence or argument to the director of the Defense Health Agency or a designee. In-person presentations are made at the Defense Health Agency located in Aurora, Colorado, at the provider or beneficiary's own expense. These are semi-informal hearings that presided over by the Tricare Program Integrity Office. In general, there is someone from the Tricare General Counsel's Office and 2 or 3 individuals from the Program Integrity Office. There are no hard and fast written rules of how these presentations are made. In general, you get to present your case. The agency may ask you questions during the presentation. The presentation may last an hour or 2 hours. They may or may not have a court reporter taking down all the information. And no decision is made at the time of the presentation. The Office of Program Integrity, along with the General Counsel's Office, makes a recommendation to the Director of the Defense Health Agency about what the material presented and whether or not to continue the suspension. However, there's no time frame either for when someone may receive notice of the outcome of the hearing. There are no rules in the Tricare Operations Manual that have hard and fast dates. So while it is possible that you may receive information back from the Defense Health Agency regarding the suspension within a week or two, it is also possible that it may take several months before you receive any word from that, from the presentation that you may make in person. However, it is beneficial to present in person. I counsel my clients that it's best to present in person so that everybody has the opportunity to review the evidence. If there are disputed material facts, then the agency may ask for an additional hearing under the appeals and hearings portion of Tricare. This doesn't happen unless if the suspension is based on fraud or criminal charges, or it doesn't. There's no hearing before the Appeals and Hearing Division on disputed material facts if a determination is made on the basis of advice of a responsible government official that substantial interests of the government in pending or contemplated legal and administrative proceedings based on the same facts that the suspension would be prejudiced. That would be in general fraud investigations, et cetera, that are ongoing. So Tricare can suspend or modify determinations for newly discovered evidence, maybe the elimination of any causes for which the suspension was invoked, or other reasons the Defense Health Agency Director or designee deems appropriate. In other words, Tricare has a great deal of latitude and leeway in making the decision to modify or terminate the suspension of Tricare claims processing. Now, there are also some appeal rights. However, no right to appeal an initial determination, which is, let me back up for a second. You receive after you present to the agency in writing or in person, you would receive an initial determination from the agency. But there's no right to appeal the initial determination if the suspension is based on suspension or exclusion by another federal agency such as Medicare or the VA, or suspension is based on a criminal conviction or civil judgment against the provider. The duration of a Tricare suspension can last 12 months, and if legal or administrative proceedings are not initiated within that 12-month period, the suspension shall be terminated unless the government official responsible for the action requests an extension of the suspension. An extension is for an additional 6 months, and a suspension may not be extended beyond 18 months unless legal or administrative proceedings have been initiated during that period. Tricare has a shorter period of time, whereas Medicare may go on a long time with their suspension just based on an Office of Inspector General designation that it still needs to investigate this issue. As I said, after presentation of evidence, either in writing or in person, the Director of the Defense Health Agency shall issue a suspending official's decision, which is an initial determination, which modifies, terminates, or leaves in force the suspension of claims processing. The notice, the initial determination, is provided to the Tricare provider by certified mail, and unless the sanction has retroactive effective date, the written notice shall be dated no later than 15 days before the decision becomes effective. So there are other things that the initial determination will include. It includes a statement of the sanction being invoked, whether you're being suspended, it could say terminated or excluded, but there are a whole lot of other rules on that, and we're just covering suspensions of Tricare and Medicare today. But a statement of the effective date of the sanction, a statement of the facts, circumstances, or actions which form the basis of the sanction, as well as a discussion of any information submitted by the provider relevant to the sanction. There's also a statement of factors considered in determining the sanction period. And this is important. It also will include the earliest date on which a request for reinstatement under Tricare will be accepted. It could be the next day that you could be reinstated. It depends on what that letter says. And the requirements and procedures for reinstatement. And it is important that a notice of available hearing upon request of the sanction provider is also included. This is so differing from Medicare, Tricare does have some limited availability for a hearing on this. Other things that the references in this entire presentation are found in Medicare 42 CFR 405.370-377, as well as in the Medicare Program Integrity Manual. There's also the Tricare regulations found at 32 CFR 199.9 and 199.10, and Chapters 13, Sections 6 and 7, and Chapter 12, Section 1 of the Tricare Operations Manual. I wanted to leave some time open if somebody had any questions that they would like to ask regarding this presentation. You can send the questions through the chat feature, and the entire presentation is included as a link in the chat. So we'll give it, if anybody has any questions, could you please ask them now or at some other time? I can answer them if you want to wait and send a question later. I can answer it. It's a very important topic. There are a lot of Medicare suspensions for fraud and Medicare general suspensions. Right now, Tricare is being very, very active, suspending providers while a pharmaceutical investigation is ongoing. So if you have any questions about this, please contact me. I'd be happy to respond to them. And I want to thank you for allowing me to present. If there are no questions, this will conclude our presentation today on Tricare and Medicare suspension. Thank you.